What are the rules for an inherited IRA? This is a question that I'm asked more and more frequently as time goes on, and it's a question that's especially important since the passage of the Secure Act in December of 2019. So let's start with what is an inherited IRA. It's just exactly what it sounds like. It's an IRA that you receive as a beneficiary of someone who has passed away. Now, the rules for inheriting an IRA depend largely upon what your relationship was to the account owner, especially since the passage of the Secure Act. Generally, a non-spouse beneficiary must start taking the required minimum distributions, or RMDs, by December 31st in the year following the death of the original account owner. What has changed with the Secure Act is that those inherited distributions must be completed no later than 10 years after the death of the account owner. So previously, you'd been able to stretch those distributions over your lifetime, and by the same token, then you'd be able to stretch any tax payments that you'd have over your lifetime or your expected lifetime as well. There are some exceptions to the 10-year rule. If you are the surviving spouse of the account owner for an IRA, then you do not have to follow that 10-year rule. If the beneficiary happens to be a minor child of the account owner, then you also don't have to follow the 10-year rule. Likewise, a disabled or chronically ill beneficiary would not be subject to the 10-year rule, and a beneficiary who is not more than 10 years younger than the original account holder would also not be subject to that rule. If for any reason you decide to disclaim or decline to inherit all or part of that inherited IRA, then that amount would pass to other eligible beneficiaries. But the decision must be made within 9 months of the death of the account holder, and that decision is irrevocable. Either way, there's a lot of moving parts when it comes to inheriting an IRA, and it's most important that when you look to get your questions answered, you talk to an attorney or you talk to a tax professional about your specific situation.